All right, well, while everybody's getting ready in the courtroom there, I'm going to bring in our legal analyst guest who's standing by watching this trial for us. Criminal defense attorney Alex Ozols is joining us from San Diego, California. Alex, great to have you on the program. Give me your take of what we've seen in court so far, please.
Yeah, so a lot of these witnesses they're calling, the prosecution, what they're trying to do is they're trying to essentially just keep putting witnesses in front of the jury. They're trying to tire out the jury. They're trying to make the jury make these connections in their head and kind of make these juries' minds run wild. Like, well, what was going on that day, even though these witnesses aren't saying that. Essentially, though, it seems like it's kind of backfiring. On this last witness, they really got nothing out of him. And then the thing that the defense got out of him was he said that he saw the defendant crying in his car, which that was actually a really bad fact for the prosecution. And, now the defense can use that in closing. They can say, talk about reasonable doubt. And they can say, you heard this individual say, he did see something wrong with him after. And people did see his affect change and so on and so forth. So, this last witness and the one before, I don't know if the prosecution's strategy is really working there. I think on the last one, for sure, it definitely backfired.
I'm with you, Alex. I really love and appreciate everything you just said. And I especially liked how you said they're trying to tire out the jury. Because you're right, it's exhausting. You have to pay such close attention when you sit as a juror in a case like this one. And as a prosecutor, and I've served as a prosecutor, I know you have to learn to try a case with precision. And you can't leave the jurors up to their own devices to figure out why they should find in favor of the state or the defendant. And here it's like I keep waiting. With every witness, are we going to see something that points to how this woman was killed? Because we certainly don't have the death declaration from the court. What do you think of defense counsel's performance in this case? You're a criminal defense attorney. What do you think of what you've seen so far from them?
Yeah, so I've actually handled the most highly publicized no-body homicide in San Diego. I've done cases like that. My client was found not guilty. In a case like this, the defense is doing a good job. In that, they just asked a quick question. That's all they need to do. What they need to do is keep bringing these little reasonable doubts in, okay? Because in the end of the case, what they're going to say is this case isn't proven beyond a reasonable doubt. And they really got to show that standard. Now, I always say to jurors, I have a chart, and I say, if you think it's possible that he's guilty, he's not guilty. If you think it's probable he's guilty, he's not guilty. Guilt highly likely, not guilty. So they just need to keep saying, hey, you have a doubt here. We've shown you the doubts, and these are the doubts. Right.
Alex Ozols, appreciate your insight and expertise. You're going to stay with us. We thank you for that. Let's go in live and listen to this next witness. Okay, while they're headed to break, I want to bring in our legal analyst guest, Alex Ozols. Alex is a criminal defense attorney in California. Okay, Alex, let's just talk about that last little exchange, because as I was watching it on our monitor, I kept saying, object, irrelevant, calls for speculation, object. Nobody's objecting in this trial. What is going on? I know you would have been jumping up and down, and then here he was trying to sort of save things on the recross. Share with me your thoughts, please.
Yeah, I felt the same way. I kind of felt like, though, like that backfired in a way for the prosecution. I mean, they had that statement, you're wasting your time, you're not going to find her here, right? And that's one of the most powerful statements in the entire trial. So this is what their whole case rests upon. They want that to be this moment to the jury. They hear it and, they start crying and they start thinking, and this is it. And she couldn't even remember it.
Right.
It's like, if you're the prosecutor, prep your witness. Like, she had to get her recollection refreshed. And then she says it, and then she says, okay, well, now I remember. And it's like the defense attorney calls her out on it and says, these were etched in your brain. This is, the most powerful statement of this entire thing. But then she forgets it. And so it's like, the prosecutors, this is the most powerful statement of your case. You need to prep your witnesses better. Like, what's going on here? So they put her on, but I feel like the defense kind of just knock that out. It's just an odd situation.
You're right. It was one of the strongest bits of evidence we've seen so far, and it went flat. It went over like a lead balloon. And then the defense team did exactly what you said. They thought, okay, this is a chance for us to hammer home the fact that she couldn't even remember it. And that's not her fault. That's not her fault. You're right, Alex. You're right. It's the fault of the prosecution. That's part of the responsibility, especially because this is an old case. We're going back 2013. Can you remember what you had for breakfast on Monday? I can't. Alex Ozols, I want to talk to you some more. We just have to take a break, so you're going to stay right there. I want you to stay with us at home. I want to bring in my legal analyst guests as we're waiting for the jury to come back from their lunch break. Still with us from San Diego, California, criminal defense attorney Alex Ozols, and in Denver, Colorado, criminal defense attorney and former prosecutor Eric Faddis. Thank you, gentlemen, for joining us. Okay, what I want to do is play a clip for you of some of the testimony we heard today. We know there was a lot of focus on coworkers and the defendant's reactions in the time after his wife disappeared. So let's listen to something that coworker Mark Blazer said, essentially talking about how he thought it was weird that James Prokopovitz showed up for work.
When you spoke to officers, you were asked if you recalled that Curly had come into work that morning, and you said that he did. Is that right?
Yes.
And with regard to that, based upon your view of what was occurring, did you further indicate that you thought that was strange?
Yeah, I did. I just, but I guess, after I thought about it, everybody's got their own way of dealing with things, but I wouldn't have went to work. I'd have been out looking for her, but everybody's got their own way of dealing with things, I guess.
And did you tell law enforcement? If my wife went missing, I'd be a wreck and would be out looking for her?
Yes.
Your Honor, I'm going to object to leading.
Yeah, I agree. You've asked a question. You have to ask open-ended questions.
Yeah, that was totally irrelevant. One proper objection there for the defense. All right, I like it. Eric, I want to go to you first, please. This little bit of testimony, who do you think it helped more, the prosecution or the defense?
I think it is, this guy was knocking out of the park for the defense. This is a prosecution witness, okay? And he's up there and he's not only is he being equivocal and kind of saying, oh, yeah, it was kind of strange it came to work, but different people, process grief differently. That's the defense's theme. That's what they're trying to get the jury to sign on with. And so for the prosecution's witness, the opposing side's witness, to help establish the central theme of the defense, I think only benefits the defense and may have been a bit of a misfire for the prosecution there.
I'm with you, Eric. Alex, what do you think about that little bit of testimony?
Yeah, I agree completely. First of all, I would have been objecting as speculation to a ton of these things. Also hearsay, also counsel was testifying. So many issues here. I would keep objecting to speculation, as I would want the jury to know, at least, like, even if the judge overruled it, that this is huge speculation. They're literally asking these people who don't even know him, what do you think maybe, basically. The second thing is, I don't think his statement really helped the prosecution at all. I mean, these people keep saying, well, yeah, he comes into work all the time. He's known to never miss work. I don't think any of these are the smoking gun. And if you keep putting that in front of the jury, I don't know if that's a good idea. And so that's a tough one.
I'm with you, Alex, and I liked all of those objection bases that you just laid out. If I were that judge, sustained, and this is a good judge, and he can't make a ruling if they're not lodging the objections, stating the basis. So yes, I'm with you right there. Lots of objectionable testimony, and it's been a real pleasure having you on the show, Alex. We're going to say goodbye to you. We thank you for your time and expertise, and Eric, you're going to stay with us so we continue our coverage. We're going to step aside, take a break. When we come back, I want to bring in our legal analyst guest now to talk to me more. Criminal defense attorney Alex Ozols is still standing by for us in San Diego. And I want to welcome to the program from Denver, Colorado, criminal defense attorney and former prosecutor Eric Faddis. Okay, so let's talk a little bit about what I was just speaking to Chanley about, and how the state seems to want to establish this consciousness of guilt to try to enhance their case by saying, well, look how he acted. Look how he acted during the searches. Look how he said things like, you won't find her. Look how he didn't seem to be upset. Is this enough? Eric, I want to go to you first, please. You've been a prosecutor. Is this going to be enough for this jury?
In my appraisal, absolutely not. Now, clearly the prosecution wants to show that we all have these expectations about what a person is supposed to do when their spouse goes missing. And, for me, if my fiance had gone missing, I would be scouring the globe, every inch of this world to find her. But as you mentioned, there's no playbook for how a person is supposed to grieve. And simply establishing that, this defendant did some stuff we wouldn't expect a person to do in that scenario, that may raise some eyebrows, but it absolutely comes nowhere close to meeting their burden of proof.
I'm with you, Eric. Well said. There is no playbook for that. And certainly it can be helpful to enhance a case, right? Alex, I want to get your take on this. You know, if there were more facts, more solid facts pointing to how something had it happen, how the death occurred, where it occurred, why it occurred, you know, then you can kind of enhance it and by the way, look how he behaved too. It further solidifies the state's position. But here it's like they're just talking about his behavior. I'm really disappointed in seeing this. Your thoughts, please.
Yeah, it's weird because, I mean, essentially what they're trying to do here is just build a purely circumstantial case. Everyone knows that. But what they basically have to do is kind of distract the jury and just kind of distract the jury away from the law, because the law is beyond a reasonable doubt. And they got to try and tell them this story and keep putting this stuff in front of their face and just hope that it sticks and just distract them from the jury. I mean, you know, this may be one in their closing where they don't talk about the burden. The defense definitely needs to talk about the burden, but that seems like it's the prosecution's theory. But when you look at these facts, you know, you think, oh, hey, this guy probably did that. And again, probably did that. You know, that's not beyond a reasonable doubt at all. And so it's kind of a weird problem we're having here on this case.
Exactly. Probably is not enough. I want to play for you, gentlemen, for all of our viewers at home, a clip from one of the most recent witnesses' testimony. Julie Hazer got on the stand. She is a friend of one of the daughters of Victoria Prokopovitz. Didn't know Victoria, but knew her daughter, Stacey Deer, so she wanted to help in the search efforts. And here she talks about something that James Prokopovitz said during the searching that really stood out to her. Let's take a listen.
Did reviewing your statement help refresh your recollection as to what you reported?
Yes.
Okay. And so, again, Mrs. Hazard, were there statements that you recall James Prokopovitz making during this search?
I did.
And what were those?
That you guys are wasting your time. She's nowhere around here, and you will never find her. And he also said, women, all they do is bitch, 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 and they have nothing to bitch about, they find it.
And those were comments you recall Mr. Prokopovitz making during the first search you were at?
Absolutely. Those are etched in my memory.
Not a very nice thing to say. Eric, I want to go to you first, please, on this, because Alex and I talked earlier, and he made the great point about how when you have to refresh a witness's recollection, it really takes the oomph out of the presentation. It's like they don't remember this really important thing that the jury needs to hear. And so talk to me about some of the behind-the-scenes things. When you're a prosecutor and it's your responsibility to prepare your witnesses, make sure they remember what they said 8 years ago to go in and testify. Tell me about some of the things you would do with some of your cases to make sure your witnesses are ready to go for a moment like that one.
Oh, of course. So, you know, as a prosecutor, a lot of these individuals are swamped. They've got dozens, if not, you know, over 100 cases that they're managing, so their time is limited. But you sort of dedicate and prioritize time for a first-degree murder case, and you prepare with those witnesses. And so what do? You know, you want to meet with them in person. You want to get a sense as to how they articulate, how they're going to express on the stand, and then you also want to go over the statements that they have made in the past. And you want to ensure that they recall those. If they give you some information that you didn't have before, you need to turn that over to defense. But you've got to do your homework on these folks, and you've got to make sure that they are ready to get up there and testify in this first-degree murder trial. And it seems that the prosecutor may have not given enough time for this witness in that respect.
I'm with you. Great points there. And it is a tough job. It's a noble profession, and it is overwhelming. You walk into court, you have a stack of cases this high, and it's prioritizing. When you have one going to trial, you do your best to organize things and make sure, like you said, you revisit all of those prior statements. That's perfectly ethical. And you have to do that. You have to prepare these witnesses because it's hard to recall things, and they have to be able to succinctly relate the information to the jury so that the jury isn't left there sitting there like, should we trust this? And then you have somebody like Alex Ozols, who's a criminal defense attorney, and he's going to go in there and take that information. Alex, tell me, if you were trying this case, what would you do with that little nugget there from just this witness, those couple statements in your close? What would you do for this jury?
Oh yeah, so I dream about stuff like that. Seeing it, I was getting fired up, and I couldn't even wait to talk to you about it. I'm thinking, if this was my case and this was in the closing argument, I'd go through each witness one by one, and I'd say, remember this witness, remember what she said, and remember this statement she gave you. It was such a powerful statement. She said it was etched in her mind forever. But then she couldn't even remember it. And they had to show her the police report to remember it. And this is the person that you're supposed to rely on to say this case is proven beyond a reasonable doubt. And you're going to convict this guy and send him to prison for life. You're going to rely on someone who can't even remember the most biggest statement that's ever happened that was etched in her brain forever. I mean, I would tell the jury that I'd look at every single one of them in the eyes. And I don't see how they could take that as a reliable statement.
I'm with you. No, absolutely not. And it falls on the prosecutor's lack of preparation. It really does, because there's no reason. And this woman, she was a fine witness. She did a fine job, not picking on her, just criticizing the advocacy, which is part of my job here. Speaking of advocacy, I want to just bounce this off you two, gentlemen. You're seasoned trial attorneys, so who better to talk to about this? I've been losing my mind here the last 3 days over the fact that no one is objecting. Are they glued to their chairs? Why is no one standing up and lodging objections? Because I've seen so many. Yesterday, there was like one series of questioning, and I said to my producer, Lauren, I said, I'm just going to count with this witness as we came back from commercial break, how many leading questions I hear this prosecutor asking. And the defense counsel didn't object once. And then we saw a little bit a short time ago where there were objectionable things being drawn out of the witnesses, and there's still, neither side is objecting. What is going on? Have you noticed this as well? Eric, share your thoughts with me, please.
Yeah, Julie, it's kind of a delicate analysis sometimes to decide when to object, because even if you have a meritorious objection, sometimes the point to which you're objecting is not critical. You don't want the jurors to say, "Oh my God, this attorney won't shut up," and he keeps creating these delays in the case and that kind of thing. So you kind of have to be judicious in terms of when to object, but especially on the defense side, if there's something that you believe that's coming out against your client that is not favorable, that's going to hurt his case in a first-degree murder trial, you've got to stand up there and object fervently. And it's a bit peculiar that hasn't happened as much as I would expect in a first-degree murder trial.
Really well said, Eric. And you're right. You have to be measured. You have to think, okay, this really doesn't hurt my case. This isn't going to make a difference. But then when you got to protect your record, it's going to waive. It's bye-bye. You've waived it for appeal if you don't make that objection. You guys know this.
Absolutely.
We're out of time on this segment, but I'm going to talk to you gentlemen more when we come back from commercial break. Thank you so much, Eric Faddis, Alex Ozols. We'll be right back here on